Matt, I'm excited to have you on here today. We've got to know each other a little bit over the past couple of years, um, and I've learned about how your practice evolved, and it's continued to evolve since then, since you left Coinbase and moved into a new role at Kraken. And so, one thing that strikes me is that in your relatively short tenure at Coinbase, 4 years, you saw two Supreme Court decisions um, were involved in directing strategy for those. So I think that's pretty remarkable, and I'd love to hear about your experiences there.
Yeah, sure. Thanks so much for having me, Karam. The Supreme Court cases that I worked on while at Coinbase, it certainly was not something I anticipated to be working on when I joined the company. I joined the company to bring some senior leadership to the company's consumer arbitration docket. When I joined, I was managing one lawyer. By the time I left, I was managing closer to a dozen, and had a very large docket of class actions and appellate litigation that had grown during my time there. And yeah, we had two cases that went to the Supreme Court on arbitration issues. Those cases, they went up together the first time, and then separately, Susky, which is the second case, went up the following term. It was an extraordinary experience. Happy to dive into the details, outside counsel selection, strategy. Happy to go in any direction you want.
I think maybe actually going back even earlier. So I think from a risk management perspective, what are things that companies, was there something inevitable about this? Was there something in reflection that this gives you new insights for, oh, here's something we could do on the risk management side that would mitigate this? Obviously, there's any number of issues that are going to get litigated regardless, where, reasonable minds are going to disagree or otherwise. And so I guess from the outset, how, with the benefit of hindsight, um, was there something that could have been predictable about this, or put another way, in the wake of these disputes, did that revise how your team thought about risk?
That's a really good question. Actually, there is, and it might not be what you expect. So Susky, that's the second case that went up to the Supreme Court, and I went to the oral argument, sat in on that, and if you go back and you listen to the oral arguments because they're public, you will see that the justices were beating up quite a bit on the lawyer for the other side, and um, I'm sure you've heard lawyers hedge when they talk about risk. Oh, nothing's 100% in litigation. I walked out of the Susky oral argument thinking that there was a 100% chance that Coinbase prevailed in that appeal and that the Supreme Court was going to reverse the Ninth Circuit below. The outcome of that case was the Supreme Court issued a 9-0 decision affirming the Ninth Circuit. So I was dead wrong in thinking that there was a 100% chance that Coinbase was going to prevail based on what I heard at oral argument. And I think for me, what it did was it just softened a bit of my confidence going into litigation, right? That you prepare as best you can, and maybe you perform as best you can. And the outcome seems certain as you're watching the trial. And the reality is that the outcome is never certain, that you never know what the judge or what the jury is going to say, and that risk always exists when you take a case to decision. And so certainly that now features more prominently in how I think about risk, that even when you've done everything right, even when the trial or the hearing goes exactly how you would hope it goes, you could still get a decision that totally upends the way that you thought the case went.
And subsequently, with things like sweepstakes, I've never litigated anything in the way of sweepstakes, and I only see what I see in things like Law 360 or from certain lawyers, their experience. It seems to me it's, let's say, something like sweepstakes or something that are often litigated, where consumers claim there's like insufficient disclosure of something,
Right.
or something misleading. And so, did that revise Coinbase's appetite for engaging in promotions like that, or different kinds of things that are consumer facing, that there's different risk tolerances that you can engage in? How did that risk calculus for what
Yeah.
the business did in light of litigation change over time.
Yeah. Well, I want to be careful not to speak for Coinbase, but I'll speak for myself and like how I think about these issues. And I'll tell you one thing that it did for me was really underscored how much of class action litigation these days is really about process and not about substance. The actual like the underlying merits of that case, Coinbase, like any company, has product counsel, has a relationship with the decision makers to decide what's the appropriate level of risk, how do you launch a sweepstakes like this, what is it that you do. But the way that I think about some of these issues and the way that they manifest in consumer litigation is making sure that you have the right process. Like, do you want this dispute to go to arbitration, or do you want this to be litigated in a court? Is there a process that you could put in place that will make resolving these disputes more efficient and quicker and less painful for the business? So I definitely think the litigation that I worked on while I was there, it directly related to that, right? The thing that the company was fighting for was about the process, was about upholding its arbitration program. And the way that I think about class action litigation to this day, even at Kraken, is influenced by a lot of those fights. That a lot of these things are as much about process as they are the underlying substance.
Was there anything about Coinbase? Other businesses launch sweepstakes as well, like a grocery store might have sweepstakes or whatever. Aside from that specific promotion, did you have the impression that Coinbase was particularly a target in any way of class actions, more compared to some other, like, take your pick of what you say is a peer company?
Yeah.
Um, was it more or less average?
Oh, 100. Well, no, definitely. Um, Look, I think you look at the public dockets of all the crypto companies, they're all targets. Like they are the exciting thing for the plaintiff's bar to go after, for regulators to look at. Um, and I think just by being like the thing that is in vogue, an industry like crypto is necessarily going to get a lot of litigation. And frankly, that was a big reason why I joined the company. It's part of the reason why I'm still in crypto. I love litigation. I love Kraken. I loved Coinbase. I love defending these companies. It's really a privilege to be able to do that. I also believe deeply in their mission. Um, and so yeah, they're absolutely uh, by nature of the industry that they're in, they absolutely do attract litigation. But that's true for a lot of companies in frontier industries. You look right now at like OpenAI or Anthropic, and you look at their litigation docket. You look at the prediction markets companies, and you look at the litigation that they're facing. Whenever a company is trying to do something new in a space that is not well defined, where the regulatory parameters are not cleanly set, where the rules of the game aren't yet the ink on the rules isn't dry. Like that's going to be the type of thing where there's going to be a lot of litigation. And my own career path, I've tried to flock to that sort of thing.
So, at what point in your tenure did it seem to you, hey, like we might have something that goes to the Supreme Court?
Yeah. I think that was when we were filing, when we were trying to get the district court proceedings stayed in both Susky and Bielski. It was sort of like a light bulb moment for me when I wasn't yet that familiar with arbitration law. I was just really beginning to cut my teeth on it. And I had looked into this issue and thought, like, gosh, like we really shouldn't be spending time or money on this if we're going to appeal. And I thought it just made sense that we would ask for a stay. And um, when I looked into it deeper, I realized it's actually not a sure thing that we get a stay. And that was when I raised my hand and said, wait a second, it's not, why not? And then we dug deeper and we realized, well, you don't automatically get a stay in the Ninth Circuit, but maybe if we were somewhere else, we would have. And then I just kept pushing, asking why? And then finally I realized, like, wait a second, I may have a circuit split that I'm holding on to. And not only do I have a circuit split that I could raise in a case that I'm bringing up on appeal, but I have two cases that are going to go on appeal to the same court for the same client in a similar posture. It seemed like a uniquely uh, fortuitous moment that if we were going to raise this issue and try to get the Supreme Court to hear it, that, gosh, this seems like as good of an opportunity as any. And I just like, once I had, I guess, my teeth sunk into this idea that this doesn't seem fair, this doesn't seem right, I never, I just didn't let go of it until the Supreme Court granted cert and ultimately ruled on it.
That's an interesting instinct, because I think it wouldn't be unreasonable for another litigator to say, "Hey, that sucks. That that the law is such a mess here. And I guess it is what it is. I guess that's what the Ninth Circuit does," and then you'd accept it and then move on. So where did that instinct come from? Is there some precedent in how you litigated cases that you kind of kept on pulling that thread? Like, because I think any number of other litigators would say, "Hey, good enough," and like we're not in the business of taking things to the Supreme Court.
Yeah. Well, I think I always try to look for asymmetries as a path to victory, whatever that is. Um, and that's just like a thread line throughout my career. Um, Shortly before joining Coinbase, there was a motion to dismiss that I filed that several senior lawyers who have tons of respect for, they thought like, oh gosh, like no way this is going to work. I had this really technical argument around Rule 15 and like why Rule 15 doesn't permit the other side to replead and the court should dismiss this case. And I just kept pushing on that argument. And I just, it resonated with me. I thought, gosh, this should resonate with a court. And I just kept pushing it. And sure enough, we got a dismissal for that client and the case went away. So I think there were a number of moments along the way where like, I kind of, got onto something and just could not get myself off of it. I think part of it too, Kerm, is that in all of these situations, I couldn't see the downside to holding on. Like, so what? Like, what if I'm wrong? What if I was wrong? What if the Supreme Court denied cert? What if the Supreme Court ruled against us? In my view, I I, I didn't see that outcome as a terrible downside. I looked at the downside as relatively low. The upside is tremendous. And if you're not going to throw the ball deep, you're not going to score a 90-yard touchdown. That doesn't mean you should throw it deep every time, but like that kind of was the mentality that I was bringing into this. Was this seems like a really good pass to throw. This is, if there's an opportunity to take it here, we should, and we did.
And then it seems to me that specific to taking matters on appeal, like the marginal cost of an appeal is relatively low relative to trial court proceedings. So it's a good investment.
Yeah, especially in a class action posture. If the case is going to stay, um, at a federal district court in a class posture, even before you get a ruling on class certification, your client may be spending millions of dollars on legal fees. So, yeah, it definitely seemed like the right bet. It was, even if we lost, like the asymmetry of what a win means if we get the win, at least for me, made it a no brainer.
Mm-hmm. And then you have some initial sense of how the pathway to the Supreme Court. How did that change as you progressed?
Well, for me personally, the way that it changed was I was learning on the job. I did not come to Coinbase as an appellate lawyer, and very quickly had a growing appellate docket while I was there, and had two cases that went to the Supreme Court. So while I had filed appeals before and had appeared with law firm partners and other associates at various appeals. Uh, and I had even worked on a cert petition long ago, early in my career. I didn't really know much about Supreme Court practice. And one of the first things I learned was Supreme Court practice is its own animal. It's not like going to the Ninth Circuit or another regional circuit. It's really its own thing. There is a Supreme Court bar. There are folks who do nothing but take cases to the Supreme Court. Of course, like they'll do appeals generally, and they'll hold themselves out as an appellate practice. But you see this increasingly with several firms that have some of the best reputations in this space. They hold that practice out as a Supreme Court practice, and once the Supreme Court granted cert, that world really opened up, and it became clear to me how this is very different from what we saw at the Ninth Circuit in terms of prep, in terms of how you think about um, who else is on the bar and might align with you, and folks who might reach out and want to file an amicus brief. There are just so many things that happen at the Supreme Court level that just don't happen in the lower courts.
So this is something that's very different than managing a case against the Supreme Court is got to be very different than managing a case that gets to district court. What were the differences there? What did you learn on the fly? And then I'm also interested, was there any precedent, anyone else you were learning from that had managed a case like this to get insights?
Yeah, for sure. So first, I think like a lot of credit here goes to my then boss, Catherine Minerick, and her boss at the time, Paul Graywall. Both of them, gave me the green light to interview some of the best Supreme Court practitioners in the country, and we ultimately ended up hiring Neil Katyal and his team. At the time, Neil was at Hogan Lovells and was working with another fantastic appellate lawyer, Jess Ellsworth, and their whole team of associates and partners. They were just all amazing. I think one thing that's different, and then just like one thing that I learned from this whole process. One thing that's different is in district court proceedings or in arbitration or cases that do not get the limelight of the Supreme Court. I'd say, I tend to have strong views on what our advocacy should say, how we should say it, and one of the things I had to do was, keep that voice in the management process because I knew the company best. I knew our issues best. But what I didn't know was how the Supreme Court was going to receive it. I also didn't have a sense of how to frame those issues to the Supreme Court because I had never done that before. So part of what I had to figure out was how to keep that voice, but also making sure that the Supreme Court practitioners who know exactly how to frame the argument in a way that's going to resonate with the justices. I had to find and navigate that balance, and so that was something I had to sort of figure out, learn on the fly. But then there was like a lesson that I learned later on, which I thought was really, really interesting, and maybe is like a good segue into how I think about relationships and team building and all of that. So, I had sort of put it to Neil and his team, or really Neil, like, how are you doing all of this stuff? And this was on the heels of a Ninth Circuit argument that I had attended with him and Jess Ellsworth that day. Like he had flown out to San Francisco. He and Jess are there for the Ninth Circuit argument. They do the argument. They then get whisked away to SFO. While they're on their way back to DC, they send me a letter that we'll later file with the Supreme Court. And then later that night, he's on MSNBC, being interviewed. And I'm thinking, my gosh, like, how do you do all that in one day? And not only do all that in one day, but do it really, really well. And so I asked him, and the feedback that he gave me was that he spends, a ton of his time focusing on his team, focusing on recruiting, that his team is his number one asset, and that becomes, by extension, the number one investment where he's placing his time. And that stuck with me. It's still one of the things I think about the most is like, am I spending enough time with my team? Am I investing enough in my team? Am I thinking enough about recruiting? Because I see the success and the leverage that, it has brought for one of the titans of our industry. And it's something that I try to continue to learn from and work off of. And it's always a work in progress for me, but it was really amazing to see that up close and at scale when I was working on the Supreme Court litigation.
So that's a good insight, a meta insight. Is there anything else from how the appellate team practiced, anything substantively or in the process that influenced how you litigated other cases?
Um, it's gonna be unsatisfying, but I think the answer is no. I think like the influence that experience gave me has a lot to do with, one, like how I think about Supreme Court practice. That like actually seeing that in play for the first time um, taught me a lot about how that appeal is different from an appeal to regional circuit courts, for sure. Um, I also think that it just had an influence on me in terms of like how the prep for that effort is different, right? Like you are not going into an oral argument at the Supreme Court without memorizing the entire record. You know where every single question is going to be coming from. You know where every single pin site is in the record. You're going to be able to spoon feed the answer to any question that the justices would ask. And it's just a completely different type of prep than what you would do for, let's say, an arbitration hearing. You just wouldn't do that. Um, and so, like, it's unsatisfying, but I think the answer on that one, Kurum, is no.
Well, okay? Is an answer then to allocate more of your team to the trial court work, so that to the extent those kinds of matters arise, you have capacity to focus more deeply on the appellate and potentially Supreme Court matters?
Um, Sorry, can you ask that again? Because I'm not sure I was following that.
Was there an insight? Part of this leverage insight is part of the insight how you allocate your time. Did it change how your calculus for saying, hey, like I need to have capacity for handling these kinds of issues, and therefore get my team to handle more issues around trial court litigation?
Oh, no, 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 no. I wouldn't say like the Supreme Court cases are what did that. I think like if anything, look, a Supreme Court case. I don't know if I'm going to see another one. I plan to practice litigation for my whole career, and I think I'm at like the 50-yard line at this point. Um, I think it's more likely than not that I don't see another one. It's very, very rare. Even if you have a large docket, even if you're at a company that's much bigger than Kraken or much bigger than Coinbase, the idea that you see one at all in a successful 40-year career, I think is really, really low. So the fact that I saw two, um, it does feel a lot like I got struck by lightning, and I do want to be like realistic about that. And so I don't think that it changes how I think about like leverage and like the litigation below and like the trial court. What I will say though is like when lightning does strike, having the opportunity to just like clear your deck and to have a team who is able to support you so you can focus on it, I think that was a gift. I don't know that it like I don't know that it by itself, Karam, is the thing that makes me think building a team that gives me that leverage, you know, um, I need to do that because I may see another Supreme Court case. But I do think that building a team that's really effective, a team that could step in and do just about anything, that's what made that possible. And frankly, when the case went up, if it wasn't for all of the issues that the company was dealing with at the time, you got to remember at about that time, Coinbase was being looked at by the SEC. There were a number of enforcement actions that were later launched against members of the industry, not just Coinbase but Kraken as well. And I think one of the things that was amazing about that experience was that uh, Paul and Catherine, who, the head of litigation and our chief legal officer, they let me lead that case. They didn't have to do that. That alone was like an example of what leverage buys you. That like if you have a team, maybe you have someone who can manage this, and there's some other bigger risk where you as the CLO or you as the head of litigation need to be at. I don't know that it was like a lesson that came out of the Supreme Court litigation itself, but it was absolutely an experience that like seeing that leverage in action and what it enabled for my colleagues and for the other leaders, I think was it was pretty incredible. And to be the beneficiary of that and have the opportunity to work on this case and have folks who were reporting to me who were able to work on the other litigation that we had. So I was able to focus on these appeals for a couple of weeks. It was truly a gift, and I'm grateful for that.
Have you thought about the counterfactual of being in house at a different company, like let's say a large tech company, being in a comparable function, focusing on let's say consumer litigation? Um, have you ever thought about what that path would have been like? Or maybe another lens on this is if someone's approaching you, say, hey, I have options, opportunities to go to maybe a large tech company or a company that's more like, say, Coinbase or Kraken. How do I think about the pros and cons between these two?
Yeah. Well, before I joined Coinbase, I don't think I knew that I was looking to join a crypto company or that I wanted to be in crypto. Um, when I joined Coinbase, I was largely thinking about the opportunity to go uh, go work on first. Catherine Minerick was a client of mine when I was in private practice. I knew what it was like to work with her. I looked up to her. I was impressed by her. I thought the idea to work with her every single day on exciting litigation at a company like Coinbase was alone reason to do it. And then, of course, Paul Graywall leading the legal team presented the opportunity to be on a legal team that had a different philosophy than a lot of legal teams when it comes to litigation. That I had worked for a lot of clients whose litigation function was regarded as a cost center, wasn't treated as a strategic partner to the business, hand in glove with the way that the business is thinking about launching its products. You have the litigators right next to the product folks trying to pave the road for the product teams to drive on. That to me was really exciting. If I was going to go in house, I wanted to be on a litigation team that was going to be a strategic partner to the business, and that's not something that you get at every in-house gig. Um, so I guess the answer to your question, Kurum, is yes, I did. Because that was a lot like what I was thinking about when I joined Coinbase. Was I wasn't thinking about it in the sense of like I want to be in crypto the way that I was thinking about staying in crypto when I joined Kraken. Um, but the North Star that I followed was where is the exciting work? Who are the A players that I'd want to do this exciting work with? And I let that kind of be my guide as I was moving from private practice to in-house practice.
How much do you weigh the there's two related components, the substantive components of the kind of work and relationships. You know, back the envelope, did one weigh more for you than the other at the time? Did that change over time?
The relationships definitely changed over time, but like the pull, the initial attraction, um, like that was there from the get-go. I think the nature of the relationships changed over time. Um, yeah.
Well, so the question is whether the substantive, what was interesting substantively about the work, um, did that composition of substantive, the percentage breakdown of why you made the move, substantive work or the relationships, was there initial, mixture for the two for between those two for why you made the move, and did that the reasons why you stayed in the role change over time?
So uh, let me focus on the second part of that question. Like, did the reasons why I made the move, like the reasons why I stayed, that change over time? I think the answer is yes, unquestionably. Because when I joined Coinbase, I don't think that I was like, um, I was excited about crypto, but I was not like all in the way that I am now all in on this idea that crypto is the technology that is going to unleash financial freedom in the world in the 21st century. It's here to stay. It's going to rewire our financial system. I also think like that's also bearing out. So like it's easier for me to feel that way now than maybe it was in 2021. So I think like that's one way in which it changed. Like I really did fall in love with the product, with the industry, and still am. Um, and I think another thing that changed was just the scope of my role. So when I joined the company back in 2021, my remit was really to focus on bringing senior leadership to a few consumer arbitrations, and I was just managing one other lawyer, and we had this function, this nascent consumer litigation function that we managed. Um, but by time I was 3 or 4 years in, I was managing class actions, managing appellate work. I took on commercial litigation. I was working closely with their institutional team. I basically was covering all of the company's litigation except for IP, regulatory, employment litigation, and shareholder litigation. So at that point, like the role really had transformed, Karan. Like no longer was I sort of like in this niche. I'm covering this broad surface area. No longer am I a manager of one. I've got a big team. Um, and I think that really changed the nature of the role and was a big part in keeping me there for as long as I was.
So I think it's interesting also to hear about how you manage outside counsel. We talked about it briefly at the Supreme Court level. I think it'd be interesting to talk about it more generally. And so something, a phrase that I thought that was really interesting that you used in our earlier calls was that when you're in-house as litigation counsel, you're the apex consumer of legal services. So can you talk some more about that concept?
Yeah, absolutely. So, and I think it's especially true in litigation. I think it might also be true for like a few other practice areas, but generally speaking, litigation is a big consumer of outside counsel budget for most legal teams. So I look at my job as being a good steward of the spend that the budget that we have to spend on outside counsel. And that means that my job is also being an apex consumer of these services. I have to do it better than anyone else would. I have to make sure that we're getting the very best value for the dollars that we're spending because it, like that it's not just my remit, but it's like it's the only way that that would make sense. um, and sometimes that means you would hire one firm for one type of thing. Maybe you would hire a different firm for another. Maybe you would bring some of that work in house. And maybe it's a mix of all of those things. But being good at that and flexing that muscle, I think, is a critical part of my job day in, day out. And I'd like to think that I do it well.
What do you do differently than, say, a comparably talented peer?
I think one thing that I'm very deliberate about is spending time cultivating relationships with the lawyers who I'm working or lawyers who I would consider working with. That, um, outside counsel will reach out to you from time to time and want to get dinner, want to get lunch, want to go to a baseball game, something like that. I am very intentional about trying to do those things. um, I think those relationships become important infrastructure for the work that the team and I are doing. And if I don't make time for those sort of off the clock meetings, then all of the relationships that I have will be just about the work. And I'm not sure that that's the most effective way to go about doing that.
What are times where you feel like you've gotten it's created different outcomes because you took that approach rather than saying, "Hey, like this is a business relationship, and we have a functional relationship, or some other version of this." Uh, Maybe you can define like this is as the relationship approach as opposed to what, and then say like the outcomes you're experiencing as opposed to what you've
Yeah.
observed for people who take a different approach.
Well, I think, look, I wish every relationship that I have with my outside counsel was just sunshine and rainbows, but it isn't always that. And I find that navigating disputes, navigating problems, navigating issues about the fees or bills or whatever it might be. All of that stuff is easier when both sides to the transaction are genuinely interested in the relationship. I mean, if it's just arm's length, if it's just about the work, if it's just like, well, we did this work for you, and you know, this is the amount it took us 20 hours to do this. This is our hourly rate. Here's our bill. Pay it or don't. Um, if that's the nature of your relationship with your outside counsel, you're not going to have any leverage to accomplish your client's goals. Um, from time to time, your objectives in any particular matter change. And when they do, you need to renegotiate fee arrangements. You need to ask outside counsel to figure out how do we meet our business objectives while also meeting our budgetary objectives. And you want your outside counsel to be a partner with you in that. So I think having a personal relationship with the outside counsel you're working with, I think that's a critical part of being able to generate those outcomes where you are producing the business outcomes that you want, and also doing that on budget. And then I think the other place where this comes up is conflicts. This, I think, is like the unspoken, unwritten, um, I don't know, undercurrent of outside counsel relationships with corporate clients is navigating conflicts. So I worked at a couple of large firms and I saw how conflicts, not even just genuine conflicts of interest, but so-called business conflicts could make it difficult for younger partners or senior associates to cultivate new business. And I've also worked at a litigation boutique where our conflicts check process consisted of me, standing up, going around the corner and asking the partner, hey, like, can I do this thing with so and so, right? So I've seen what different platforms, how different platforms navigate conflicts, and I've always found that navigating conflicts with large firms is way more challenging than navigating conflicts with smaller firms. And so um, when you have one of those conflicts, being able to call up the partner and level set about like, we cannot have, X, Y, and Z happen. Like, this is going to be a problem for the relationship. How do we fix this? Separate and apart from like what's an actual conflict of interest, right? These discussions about business conflicts are very serious conversations. They happen. I don't think they get, reported about. There's no playbook about how to navigate them. But I do find that having the personal relationships, there have been several times where I've been able to call up the partner who I have the personal relationship and say, like, this cannot happen. Like, it cannot happen this way. How do we fix this? And we almost always get to a good place. And I credit the personal relationships for that.
On the flip side of that, how do outside counsel who are looking to uh, be go-to counsel for you and someone that you rely on, how do they earn that
Yeah.
trust, judgment, connection?
I think it takes time. If the stakes are low enough, it just, maybe it just takes reps. Like if it's someone who is going to work on low stakes matters, it's pretty easy for me to give a firm like a trial matter if I'm looking for new counsel to take on a piece of the portfolio that's relatively low stakes. But I think like, for most, like if I was to like pinpoint to like, here's a thing that I think more outside counsel should do if they're trying to develop business and want to break in with a new client, find out what that client's legal problems are and keep them briefed on the state of the legal landscape, and how they could go about solving those problems. The example that we talked about, Karam, before this podcast, you'll remember I was telling you about this outside counsel firm who reached out to me this was back when I was at Coinbase. They wanted to share some of their insights about consumer arbitration, class actions, mass arbitrations, all of the things that were like right up my alley. And the ask to me was, are you open to just having a conversation with us for an hour about the current state of the law? No strings attached. We just want to tell you what we're seeing. Sure, why not? What's the worst thing that could come of that conversation? It's a waste of my time. I don't have to have another conversation. Why not? And so I had that conversation, got a ton of insight about what's happening in that area, learned a lot about um, some things that were happening on the plaintiff side, developments in the space, and thought, we should have this conversation more regularly. So we had that conversation on a monthly basis. And then a few months in, I brought my team with me. So I said, you know what? I don't want to just hear this stuff in a vacuum. I want the leaders from my team to hear it as well. And so more time goes by. Now we're like 10 or 11 or 12 months in. We've had a dozen of these conversations. They know me, I know them, I know what they're capable of, and so does my team. And then we finally get a matter that's like right in their sweet spot. And suddenly they become one of the first calls on the RFP to pitch for the case. And sure enough, they ended up getting it. And to this day, that firm is among my most trusted advisors on issues relating to class actions and mass arbitration. Um, and the firms that have done that, there's actually a couple of other firms that have done things similar to that. And I keep those conversations going just so I have like a mental Rolodex of, this is where I might deploy this person. This is where I might deploy that person. Going back to what you were saying before, Kerm, about being an elite consumer of legal services, like this is what that means. Figuring out how to put the right people in the right place for the right matter is it takes time, it takes cultivation, and it takes hours upon hours of conversations.
Is there anything apart from substantive expertise that goes into your judgment for how to allocate litigation?
Um, I've had so many outside counsel who pitch me and they'll say, don't let it be about cost when we make the decision. It's often about cost. Um, and that doesn't mean that the practice of law is supposed to be a race to the bottom, but different matters have a different value to the litigation portfolio that I manage. And I try to move and this goes back to trying to be a good steward of the limited budget that we have. I try to move my more of my budget to the matters where the potential for the fire burning brightest is highest. And I try to reduce spend on areas where the likelihood that things will exacerbate or blow up, that those, it's relatively low. So I do think like cost is a big part of it, and happy to talk more about how I think about that. It's not as simple as what is your billable rate.
Sure. Tell me about how you think about cost then.
Yeah. So I think, look, if you've got a bunch of, if you're doing an RFP, for example, and you've got a bunch of firms who all, say like, oh, I think it will cost like this to do a motion dismiss. I think it will cost that to go through discovery. I think it will cost that to get to summary judgment. I've never had one of those loose budgets ever hold up, ever. And when firms present their hourly rates and they say, look, like we're like doing this really steep discount on our hourly rates. Look at what our hourly rates are. I rarely look at those hourly rates and think that tells me where the value is. That fundamentally, when I go back to my clients at the business and have to explain, this is where I'm spending the team's money, this is why we're spending it a certain way, it's the bottom line that the business is looking at. They're not interested in the hourly rates. They're not interested in the discounts. They're not interested in what the budget was or why you didn't meet the budget. And so increasingly what I try to do is I try to encourage our outside counsel to move as much work as possible to fixed fees or alternative fee arrangements. And, sometimes the firms like to push back and say like, well, it may be more expensive if you do it that way. One, I don't believe that. But two, even if that were true, what it does by moving predictable sets of work into fixed fees is it gives you an opportunity to do an apples to apples comparison when you're doing that RFP. That one firm may be, $1,000 an hour for this lawyer, and another firm may be $1,500 an hour for that lawyer. But the only way you could do a true comparison of what it's going to be like if you hire firm A versus firm B is by getting something that puts it to the firm, not just a loose budget, but like, this is how much we're going to pay you to do this scope of work, and get that as a fixed price. And when you could do that and then compare apples to apples, not only can you make a decision that takes price into account, but you also can foster better price competition. That when outside counsel says to you, don't let this be about price, you can go to them and say, look, you said don't let this be about price. You proposed that you would do this scope of work for X, but I've got this firm over here that said that they would do it for Y. And if you don't want it to be about price, I need you to get down to Y. And now you have like real price competition on this work, rather than trying to match rates or trying to get estimates that ultimately don't bind the spend.
Yeah, it occurs to me that another benefit for you managing a number of litigations is fine, it might cost more in money, but that means if there's more certainty around it, that means it costs less of my attention, and attention is scarce.
Yeah, it's not a really great use of my team's time to be going line by line through invoices and questioning like, why did you spend point 0.9 on writing this email? Um, I'm sure anyone who's listening to this who is or has been in private practice, they have no doubt received that email from a client who has said like, hey, take a look at this. Like, why did you spend so much time on this thing? It just seems like a really weird way to do the economics, and yet like that's how our industry works. Is the expectation is like they'll chuck the invoices over the fence and the client will go line by line through them. Of course, that work is now made a lot easier by AI. So, I suppose like the marginal cost of doing that type of evaluation has gone down considerably over the last couple of years. But still, it just doesn't seem like a really good use of anyone's time. The lawyer who is best positioned to manage the cost and scope creep is the relationship partner running the matter at the law firm, not me, not my team. Where my team and I can add a lot of value on the management side is by articulating and defining what the company's strategic objectives are, and providing some insight or views and input on how we believe we get there. But it's outside counsel's job to go deep. It's our job as in-house counsel to go wide. And the only way that that actually happens is if, by going deep, outside counsel is not just going deep on the law, but they're also going deep on the management of their team.
How do you translate when you are going back to the business? How do you translate spend on a matter into objectives for the business? How do you translate that in terms of, hey, accomplish this gets us this certainty. Accomplish this creates this outcome that improves our performance as business. How are you translating that? And then the related question then is, what is it you want outside counsel to know in order that they're better able to translate their work into something that ultimately the business values?
Yeah. So with my clients internally, which, at Kraken, it's really the executive team, the CEOs, the chief legal officer. I think it's critical that I understand how they think about what's important to the company, um, what our litigation team should be doing, what are the fights that we should be having, what are the hills on which we should be willing to die versus the ones where, this isn't really worth it. That just requires time. And just like how I spend the time with my outside counsel building those relationships and making sure that it's not just arm's length, but it's really a personal interest in my and my team's success, I do the same with my clients. I want to understand how they think about risk. When I speak to them one on one, I try to ask them questions about how are you thinking about these things? What are the things that are important to us? And then whenever, once it's clear to me what those things are, I try to advocate for those things whenever possible, whether it's through my own advocacy externally on social media, or perhaps behind the scenes with our outside counsel, making clear like, hey, this is our objective, this is the thing that we need to do, this is the thing that we need to say, how do we get this across in the brief, this has to be the thing that is conveyed to the judge. It's really all about understanding uh, where my clients are coming from and making sure the advocates who are going out to have those fights are conveying the things that are important to the clients.
And then how can outside counsel better position their work product to help you, set you up for success?
Great question. So for anyone who wants to do work with Kraken, I think the first thing you could do is you could read the Kraken culture doc. And I'm no longer a lawyer for Coinbase, but like I would imagine reading the Coinbase culture doc is probably a good idea too if you were trying to do work for Coinbase. Um, and the reason why I say that is because when companies put materials out that try to define or describe who they are, and you are angling to be the advocate for those companies, you really ought to understand who they are. And there's like this resource out there where you could learn about that. You can understand, you can get a sense of what are the things that make Kraken tick, what's important to Kraken. Why, how do they think about communication? How do they think about um, the fights that they're having? What is the mission of the company, and how are they going to go about accomplishing it? There's a lot there, and I've spent a lot of time with my outside counsel on a few matters where we're really fighting for a principle and it's not economics. And I had been quoting to our outside counsel from the culture doc that like this is the way we need to be thinking about things. And yeah, so I think like that's like one easy tactical hack there, Kerm, is like, know your client, and some clients have culture docs, and that's one way to know them. Um, but another way to do it is, when you take the client out for lunch, you take them out for dinner, or you take them to a baseball game, ask them like, what's important over at Kraken? What's going on? Like, what's top of mind for you guys in the business side? Like, you could go on and read the news and see what's, the new products that we've launched, the aspirations that we have, the markets that we're breaking into, our policy advocacy. You'll even see a number of things that I've put out there about our litigation advocacy. But actually getting in with your clients or prospective clients and understanding what are the things that's keeping the business up at night, the behind the scenes stuff that maybe doesn't make it to the culture doc or to the advocacy that you see on social media. I think it's exactly the type of thing to focus on.
What's the most underrated thing that outside counsel can do to help you?
Most underrated thing. I don't know where this sits on the distribution curve of ratings, so maybe this isn't underrated, but responsiveness. I think it's so maybe I'm just gonna reject the question and say like, what do I think is the most important thing? I think responsiveness is probably the most important thing. Even if you're busy and you can't get to it, just being able to respond or have an associate who's able to respond, someone who's able to say like we got this. Is this an immediate thing, or like do you need this in a couple hours? The responsiveness is critical, and I try to be responsive to my clients, and so I expect my outside counsel to be responsive to me. And I think responsiveness is, at least for me, been a big part of my success. And I suspect the outside firms that do it better, those are the ones that will be more successful.
What does responsive mean to you? What's the significance of responsiveness?
The significance is that, at least with the clients so it's two things. One is it's a feeling. It's a feeling that like your client matters. It goes to good client service. It's about how you treat the profession. If client service is important, then that means that you treat the client like they're the most important thing in the world. And so you let them know, like, I got this, I'm getting back to you. And that feeling that you convey of you are the most important thing to me, that builds trust. And in an attorney-client relationship, that trust is so critical, especially when things go wrong. This is what we've been talking about the value of personal relationships. And so, right there, I think that's one reason why responsiveness is important. But I think more of a concrete and objective reason for the last two clients that I've had as an in-house attorney, both of those clients move very, very fast. They're both, they're both in crypto, a frontier industry, and the ground moves underneath you every single day when you go to work, and that's the pace at which we're operating. So separate and apart from it's just good client service and it conveys the right feeling to your client, this is like this is the speed at which your client is operating. There may be some clients where like that's not the expectation. It's never been the case for me. Like my speed has always been very, very fast. And I think meeting your clients where they are, that's part of the job. And my clients move fast, so I have to move fast.
You mentioned trust that comes from that responsiveness is a proxy for trust.
Yeah.
I can imagine the ways in which it's important to be able to trust your outside counsel and the ways in which you want to flow information that way. How does a trusted relationship influence in the other direction? What does it influence for how you interact, what you communicate with outside counsel?
I'm sorry, let me just make sure I'm understanding this. Because I think the beginning of the question was talking about trust going one way, and I'm not sure which way was which. So maybe you could.
Yeah, so
Yeah.
I can better picture what it's like to be outside counsel in the way that not having high enough trust could impact how they service in-house counsel and what they communicate in that. But what is the impact, or conversely, let's flip it on its head. Let's say in a high trust scenario, I can imagine the ways in which outside counsel are able to communicate service their in-house clients. What happens in a high trust scenario that you are able to do? What does high trust do on your end as far as what outside counsel gets from you?
I see. What are they getting from me when the relationship is high trust? Well, for one thing, certainly a longer leash and more autonomy. That's for sure. Um, and in a way, I think that gives them a little bit more freedom to do their job really well. And I recognize that there is a cost involved if I am too in the weeds with my outside counsel, if I am too directing, too much in the mix. If I become part of the work product itself, that work product is probably not the best expression of what those lawyers are capable of because I'm constantly over their shoulder in a way that could be counterproductive. So there's a balance there that I have to strike. But once I'm in a relationship that's, we've been in the trenches together, we have done a number of briefs together, we've done prep for trial together, we've done all these things, then it it allows me to step back uh, and hopefully provide more strategic guidance and then focus on other things. It provides me more leverage. So it's not just giving the outside counsel freedom to execute, but it's also the leverage that I get internally, which allows me to focus more on things like, look, here's what's important to the business. How do we land this with this person? How do we incorporate the inputs from all of these different teams rather than the brief really needs to start with this? And then, why aren't we hitting this legal point, right? It's the strategic versus the tactical. And in a perfect world, I would spend most of my time working with outside counsel, focusing on the strategic and not as much on the tactical. But that takes time before I'm able to focus more on the business strategy and less on the individual litigation tactics. Um, does that sort of get at where you're going?
Yes.
Yeah.
And then in terms of managing work product, something else was interesting that we talked about was how you inverted a weakness into a strength. So as a litigator, it's perceived to be a weakness to not really want to read, to not want to read carefully.
Yeah.
But it seems like you flipped that on its head.
Yeah. That's right. So, confession, I don't like to read for fun, which I think is rare for litigators. I mean, I read a lot. I obviously read a lot. I'm a litigator, so it'd be strange if I wasn't reading. Uh, but I don't sit down with like a 300-page book on the weekend and put my feet up on the couch and start reading. That's just not what I do for fun. Um, and what I found over time is that aversion, I don't know that it's really like I don't like reading as much as it's I don't like reading bad writing. I really don't like that. If I'm reading something and it's choppy or I'm not following, I just get bored and frustrated. And it's hard to write well. It's not it's not easy. It takes time. Um Most of what my outside counsel delivers to me is too long, it's too fluffy, it's too convoluted, it doesn't get to the point. And I think that view, that aversion to reading stuff that is just challenging to read has made me a much better editor. It's made me understand like this is the message that we need to get across. This is how we get the message across. And when I've worked with outside counsel, the thing that I probably spend more time on when I'm working on briefs, I probably spend more time in the first sentence than any other sentence of the brief. Probably spend like, 5 to 10 minutes just focusing on that first sentence, the very first thing that the law clerk or the judge is going to read. And then I probably spend as much as 30 minutes with just the introduction. And I might spend another 10 minutes with the rest of the brief. So I'm devoting 90% of my, or 80% of my editing time to really the beginning of the brief. And the reason why is because that's your first impression. That's your opportunity to persuade the reader. Keep reading. You're going to like this. This is interesting. Keep going. But wait, there's more, that's what the introduction is for. And when I was a junior associate, I'd write these really formulaic introductions, these very formulaic briefs. I look back on some of the stuff that I wrote and kind of embarrassed by it. It's not interesting to read. Um, it is not going to capture the law clerk or the judge. It was good. They're good briefs. Got winning record along the way to show for it. But man, there's really an opportunity for improvement there. And as I've gotten further along, particularly becoming an in-house lawyer where you're reviewing brief after brief after brief. You're managing a large litigation portfolio. You're getting tons of reps in. You see tons of outside counsel work product. And now, more so than at any point in my career, I'm like laser focused on what is our story? How are we conveying it? Are we using the right tone? Are we structuring the brief the right way? What's the message that we need to get across? So I think that's um, I consider that now like a strength, my editing ability, even though you will not catch me on the weekend with a large book in hand and coffee or whatever it is you would picture your typical litigator is doing on their spare time. That's probably not me.
Are there other weaknesses you've inverted into strengths? Or it sounds
Uh,
like the interesting thing you're saying is, hey, you discovered or built the skill of editing.
yeah.
So like a strength you built as a result of some initial weakness.
Yeah. So I think this is somewhat related, but writing. So as an in-house lawyer, most of my communication occurs over Slack, and it's I could if you get me on a topic that I'm interested in, Karam, we could go for several hours, no problem. Um, and if I just take the format in which I speak and convert that to writing, it would be impossible to follow. It would just be gibberish. We're having a coherent conversation here. It's going well. Hopefully you're following me. Hopefully your listeners are following me. But if we just took the transcript and put it into a Slack message, this would probably read as like the most ineffective form of communication in the history of communication. So one of the things that I think I've gotten really good at is communicating complex legal concepts, difficult decisions into very short decision ready format, a very short decision ready format that executives and clients can easily turn into action, or to follow up questions that don't go down rabbit holes we don't need to go down, but really zero in on the issues that are worthy of further discussion. And that took a lot of time. Certainly when I started as an in-house lawyer, I was not good at this. And it took a number of reps of just, teeing something up over Slack, not getting an answer, not getting resolution, not getting a decision, having things pile up, then having to go into meeting after meeting to convey what's really going on. And realizing that, hey, the problem here isn't that I don't have the answer, or I don't have the right idea or the right analysis. The problem is I'm not teeing up the decision makers to decide as easily as I could. And yeah, I think I've gotten a lot better at that over the last 5 years for sure.
So what changed? I imagine from the outset, like maybe like the number one rule is, let's say, brevity. Okay, so okay,
Yeah, for sure.
maybe okay. So it sounds like you agree with that. Okay, fine. So
Yeah.
brevity aside, let's go to number two rules. Like, what is it that changed? And I'm sure initially you were brief and succinct and
hmm
believed, hey, this is what is going to help someone act on this in a short period of time. And you were finding that people weren't resonating with that. What is that's changed? Like, what if there's a number two principle you're using now? Like, what is it that you're doing that's making your work product actionable?
So two things. First, I think it's important to know like what your story is in a single sentence. In any piece of communication, doesn't matter if it's a brief, a Slack message, an email, whatever. What is the thing you're trying to convey in a single sentence? Lawyers will get into a trap there and then write a 45-word sentence. So don't do that. But really try to figure out like what is the thing you're trying to convey. Very short, hopefully 15 words at most. Once you have that, and so that's one principle I think of is like, what's the point? Bottom line, single sentence, what is it? That's one tactical step that I take. But then the other is like, once I've got a piece of written work product in front of me, whether it's my own writing that I'm editing, someone else's writing that I'm editing, I'm looking, especially in like the introduction or the beginning, I'm asking whether every single word is doing work in those sentences. So if I've got a 15-word sentence, I'm like scrutinizing every single one. Like, oh, there's a preposition there. Did we nominalize something that should have been a verb? Like, like really beating up on every single word to get to a place where the writing itself is very high signal, very low noise. And look, that goes hand in glove with brevity. Like basically what I'm saying is like a lengthier version of brevity. But it's true, right? If you write in just like 25, 30, 35-word sentences over and over and over again, and every single sentence starts with a transition word, it's going to be really challenging for your reader to follow you. It'll be much easier if you have several short sentences that maybe go in a certain cadence, and then there's like a long sentence at the end, or perhaps like there's a long sentence up front followed by several short sentences. But mixing it up with a rhythm and a cadence that's separate from how do I just pile all of my ideas into this data dump. That's part of your job as a writer, is figuring out how to get the ideas from your head into someone else's with as minimal packet loss as possible. Like that's really what you're doing with the English language. And yeah, I think like thinking of my job like that as like, that's what I'm trying to do. I'm trying to plant an idea in someone else's head. And the English language is this like really imperfect medium that I have to do it, but it like, that's the tool. That's what I have to do it with. That's what I'm bringing to it. I guess the other thing too that I look at apart from like, is every word doing justice, is I tend to scrutinize use of adverbs and adjectives. Like if you looked at my Claude instructions, you'll see like no adverbs, no adjectives, no M dashes unless absolutely necessary, like really trying to let the verbs and nouns do the work. Um, I think it's really challenging when you're a litigator because you have so much to say. You have so many ideas. You want to get them all out there. And you got to exercise restraint because when you're writing something, you're trying to do something that's very precise. It's very, very hard. And you need to bring a lot of scrutiny to the words that you're going to put on the page.
So I'm interested in going back to something you talked about earlier in the context of the Supreme Court decisions that you pursued, just the Supreme Court appeals, and you said these are asymmetric bets that you're making, and so
Yeah,
why not take an asymmetric bet? And then you said my career has embodied a number of those. Talk me through the asymmetric bets that you see in your career.
sure. So I think the real, like, I'm just going to go through a couple. So I was at Shepherd Mullen for about 5 years. That's where I spent most of my associate years. Most of that time was in their Washington, D.C. office, and I spent 1 year in San Francisco. And when I came to San Francisco, the thinking there was my wife and I were living in Washington, D.C. Um, I was in a government contracts practice. I'd kind of fallen into that. That wasn't what I wanted to be doing my whole career. What I really wanted to be doing was litigation, and ideally litigation for Bay Area tech companies. That was where I really wanted to be coming out of law school. But that just wasn't where I landed in my first job. I ended up in this government contracts world. And when we came to San Francisco, um, you know, I wasn't able to transition my practice in the direction that I wanted. And I was already I think a sixth or a seventh year by that point. And Karam, you're a recruiter, and I've read your blog posts. You know how easy it is for a sixth or seventh year to lateral over to another law firm. It's tough. And I had interviewed with a number of other large firms, and like those interviews all went well. And my goal was to like transition my practice into something that was more Bay Area focused. And my timing just did not line up with the models of these firms. And I finally got a call from a recruiter who told me about this law firm that was just being started um, by a lawyer who was a partner at Boyd Schiller and had led litigation at Tesla and Solar City before that. And they have a number of clients in the tech industry, and I would get to join as their first associate. Sounded like a totally made up job, right? Like there's no way that this exists. This is a real thing. It was very real. And I ended up joining the Norton Law Firm in 2018, in September of 2018. And when I made that decision, a lot of I did good work at Shepherd. I had a good reputation at Shepherd. And a lot of the partners who I had worked with came to me to ask me like, hey, like, are you sure you want to take this risk? Like, this seems like kind of unusual. Like, what I know about you seems like a large law firm is where you should be, and you're going to now go to this brand new thing, and who knows what's going to come of it. Like, one partner said to me, have you considered the risk of you leaving? And I responded by saying, have you considered the risk of me staying? And what I meant by that was I was trying to take my career into a certain direction. And while I probably could have stayed at the firm and continued to do good work and continued to be a valuable member of the firm, I would have been a valuable attorney inside of this model that they had for me. But the model that I had for myself of what I wanted to do required me to step outside of this conventional path and to say, how do I transition? Like, what's the best way to transition my practice towards doing litigation for Bay Area tech clients? And I couldn't, it was so obvious once I had interviewed with Fred and Bree, who started the firm, that they were the lawyers who I needed to be working with, 110%. That I was going to get the experience of working with a whole bunch of tech clients. We would probably do more trials. We'd have like a different economic model that would probably make it easier for us to develop business. So it was an asymmetric bet, and in the sense that like if it went uh, really well, it was going to go really, really well. But I think the folks at the time saw it as unconventional, and they seemed to think that there was like this dramatic downside of me stepping off of the ordinary associate big law ladder. And what they hadn't considered was that if that downside materializes, like if I went to the firm and it didn't work out, I was going to figure out the next thing, whatever that was. It's not like your career just ends. Like you have an opportunity to then do something else. But I saw it as if I stuck around, the likelihood that I would be able to transition my practice to the direction I wanted was very, very low. And the likelihood that I would successfully transition my practice to, tech, litigation, something more entrepreneurial, the likelihood that I would succeed in doing that, whatever that meant, was very, very high by joining the Norton firm. And that turned out to be right. I did a lot of great litigation work while I was there for a number of fantastic tech companies. The firm has grown considerably since I was there. I think they now have like 20 lawyers. So, being the first associate is kind of like a point of pride for me personally, that, hey, I was there at the beginning, and it's still a lot of fun to go back to the office and like talk about the old days when it was just the three of us in a small office in Oakland together, and now they're in this big corporate office right in the middle of downtown Oakland. um, and all of that work that I did with them led me to one of their clients, a company called Coinbase. And then, the rest is history, right? Had the 4 years with Coinbase. I'm now leading litigation for Kraken. But that all was possible because I made that asymmetric bet. So that's one example. There are others along the way, but, should probably stop there because I think like that's the big one. That's certainly a huge inflection point in my career, where I really took that bet on myself.
So something that's becoming a theme on the podcast is lawyers who are practicing at the edge. And so I think that's why I was particularly interested in having you on here,
Yeah.
because crypto is at the edge, and that's where you've gained a lot of experiences that would be less common, the Supreme Court decisions we've had earlier, among other experiences.
Yeah.
And what I'm interested in is you also reference, hey, I don't know what comes next. It's going to be very relationship driven. And part of my question then is, I think a question for people who are at the edge is it, now that you've hit on something that's grown, like you're at the edge, and now the edge is, what was the edge is now the middle. And you can take up space in that middle. I'll have to think of a better analogy. This is not like the most vivid, compelling. Going from the edge to the middle is not exactly a compelling thing. But the point is that, look, you hit on a vein that you can stay in. So so crypto, your thesis, you're very bullish on crypto. This is going to endure. Companies like Kraken to grow, companies like Coinbase are going to grow. Fine. So I guess the question is then, is your instinct stay in? I think a way that I've put this before is you've hit a gold mine. Okay, hit a gold mine, and so one takeaway is, hey, there's a ton of gold in this gold mine. I got to dig more gold out of this gold mine. Another takeaway is, hey, I hit a gold mine. There must be other gold mines around here. So is your takeaway at this point? Of course, this can change. Is crypto is the thing where like this is where my experience is going to be so valuable, and that's what I love to do, is be valuable based on expertise? Or is the thing that you really want to value and cultivate is your ability to take those asymmetric bets? And so is that the next thing for you, to pursue whatever is at the edge again?
Yeah, so it's definitely the latter. I love crypto, and if I spend the rest of my career in crypto, I think I'll be super happy, and we'll have a fantastic ride. This is a fantastic industry. I love the people who are in it. If I'm fortunate enough to be in it for the rest of my career, that would be great. Um, that said, like the way I think about myself is as a generalist. and not as a specialist. I had kind of taken this path. My whole career path is specialist to generalist, right? Like I fell into this hyper specialized practice at the start of my career that I didn't even know existed when I started law school, called government contracts. Like, how is that its own practice area? Well, go to DC. There are plenty of government contracts lawyers. It's definitely its own thing. It's a very complex area of the law. And there are a lot of interesting issues, especially now with like the advent of defense tech. There are a lot of interesting issues that those lawyers have to tackle. But I never saw myself as a, fill in the blank lawyer. Like I saw myself as maybe like the closest thing to a specialist in how I saw myself was a litigator, right? You graduate law school, you have to make that decision from the outset when you're doing OCI. Do you want to do transactional work or litigation? Weird fork in the road you have to make before you ever know anything. But my choice there has been litigation. I think that was the right one. I think it reflects what I'm interested in. And despite me being interested in litigation generally and having an interest in a wide range of legal subjects, right? Not just uh, finance or crypto. Um, I took securities regulation in law school. Is absolutely something I wanted to look into. But I also looked into like IP and copyright and antitrust and other areas of the law, right? And I just kind of wanted to keep pushing myself down that generalist path. And even now, um, as the head of litigation for Kraken, right? My title is deputy general counsel, and that word general, I think it's a really important qualifier about what I do. Yeah, I manage the litigation team and I run litigation for the company, but um, I get all sorts of weird, squirrely questions all the time that have nothing to do with litigation. They may be like a commercial question or regulatory or IP, and you kind of just have to figure it out. And that's the fun part about being an in-house lawyer is if you like being a generalist, if you like having to dig in and figure out the answer, not just knowing the answer reflexively of like, oh, I've done this thing, 470 times. This is exactly what you need to do, right? But instead having like a framework and first principles that you start from to solve a problem without knowing where you're going to go through this process, but you're confident that you're going to solve the problem. That to me is much more exciting. That's why I became a lawyer. That's the path I see that I'll continue going is like down this generalist path. Um, and if it keeps me in crypto, great. And if it doesn't, that's fine too.
Yeah, it's interesting because your career embodies that path to journalism. That like you have taken these bets that are betting on yourself to figure things out, and it just keeps on happening. That there's this flywheel of well, then I have a broader set of kinds of issues I've seen before, and that means I will be able to solve things going forward. I think it's when you practice law at a large law firm, it's a lot clearer what these specialist flywheel is, and there is one, and it's very valuable. But now I think I've got a better sense of what the generalist flywheel looks like from your path.
I think that's right. And I also had the right mentors, um, people to learn from along the way, right? Like thinking back to my time at the Norton Law Firm, and this is, Fred Fred Norton and Brehan built that law firm with the principles and approach that they wanted their ideal law firm to have. And one of them was if you want to work for a firm that does like one specific thing, does it really, really well, and does it over and over and over again, that's fantastic. But like, that's not this firm. That's not what we do. We're a litigation boutique. We solve all sorts of problems when they get to the dispute stage, but not, just antitrust litigation. And that to me was exciting, not just because like, that was uh, it was exciting not only because it was something that was different than the model that I was shown before. It was exciting because it 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 told me that I wasn't crazy. Going back to that partner who said like, hey, have you considered the risk of you leaving? Right? What if I'm not crazy? What if this bet isn't like, what if I'm not making such a crazy risk? What if, in fact, this path that I want to have for myself, the only thing that's standing in the way of actualizing it or not is just me? That I just have to make the decision to jump in and to go for it.
Mhm.
Because here were two very successful lawyers with a very successful, what I think you could argue is a more like traditional career path, right? Associate at a large law firm, partner at a large law firm, go in house. That was their career path before they started the firm. And then they started the firm. That's probably like the break with convention. And I thought, wait, if these two lawyers who I look up to, who are more successful than me, who are further along in their careers than me, if they can make this bet, and they're looking to hire someone like me to make it with them, why not? Like, why can't I? What is the downside? So I think like sort of rejecting those boxes that people try to put you in is a critical muscle to build if you're trying to break away from career paths that sort of are like preordained or expected, which was absolutely the direction I was heading.
Yeah, I think that gets the essence of what is interesting about your path is the unconventional nature of the path,
Yeah,
and how you had to tune into your own judgment calls as you progress. And so we talked about how you did that substantively, and yeah, I think it's very admirable, and I think it's going to be valuable for other lawyers to hear that um, about those options. So you did it. You accomplished what we
awesome.
were hoping to accomplish.
Awesome. Um, Well, we said when we spoke on the phone that we could easily fill 2 hours with this, and I just looked down at my watch, and it looks like we did.